Question number 601. Section 75 of the Indian Evidence Act 1872 deals with public documents, private documents, certified copies of public documents, proof of other official documents. Here correct answer is option B, that is private documents. Question number 602. What is a private document? Option A, document executed in a family, secret document, document in custody of a private person, document other than a public document. Correct answer is option D, that is document other than a public document is a private document. Question number 603. Public document under the Indian Evidence Act 1872 can be proved by oral evidence, the writer of the certified copy, any of the above. Correct answer is option C, that is certified copy. Question number 604. The procedure for getting certified copy of a public document is set forth in. Correct answer is option B, that is section 76 of the Evidence Act. Question number 605. What type of secondary evidence relating to a public documents may be given? Oral evidence about the contents, certified copy of the document, photostat copy, written admission. Correct answer is option B, that is certified copy of the document. Question number 606. Choose the correct option under the Indian Evidence Act. Judicial notice, section 87, private document, section 75, admission, section 48, accomplice, section 132. Here we have to choose the correct option. Correct answer here is option B, private document is in section 75. Question number 607. Under which section of the Evidence Act provisions for the presumption as to gazettes in electronic form has been made? Correct answer is option A, that is section 81A of the Indian Evidence Act. Question number 608. Section 81A was added in the Indian Evidence Act by the Information Technology Act 2000 to provide the presumption as to electronic agreements, electronic messages, electronic records, gazettes and electronic forms. Correct answer here is option D, gazettes and electronic forms. Question number 609. Which of the following is correct? There is a presumption that maps of various states and union territories made by the Survey of India are accurate. There is a presumption that map prepared by a registered architect for the purpose of civil disputes is accurate. Both A and B, neither A or B. Correct answer here is option A, that is there is a presumption that maps of various states and union territories made by the Survey of India are accurate. Question number 610. Due execution and authentication of a power of attorney shall be presumed under section 85 of the Evidence Act when executed before and authenticated by a notary, judge, a magistrate. Here option D is the correct answer, all of the above. Question number 611. Which one of the following sections of the Indian Evidence Act 1872 is related to presumption as to electronic agreement? Correct answer here is option D, that is section 85A is related to presumption as to electronic agreement. Question number 612. Presumption as to electronic records and electronic signatures is provided in option A, that is section 85B of Evidence Act. Question number 613. Which kind of agreement can be presumed by the court under section 85A of the Indian Evidence Act? Written agreement, oral agreement, electronic agreement, none of the above. Correct answer here is option C, that is electronic agreement. Question number 614. Under section 85C of the Indian Evidence Act, the presumption as to electronic signature certificates correctness, the court may presume, shall not presume, may not presume. Correct answer is option B, that is shall presume. Question number 615. The provisions relating to presumption as to telegraphic message is embodied in the Indian Evidence Act section. Correct answer is option D, that is section 88. Question number 616. Which of the following is an example of may presume? Presumption as to electronic record, presumption as to digital signature certificate, presumption as to electronic messages, presumption as to electronic agreements. Correct answer here is option C. Presumption as to electronic message is an example of may presume. Question number 617. Which provision of Evidence Act relates to presumption as to documents 30 years old ancient documents? Here correct answer is option B, that is section 90 of Indian Evidence Act. Question number 618. 30 years old document if produced from a proper custody, court shall presume its execution, court may presume its execution, presumed not involved, none of the above. Correct answer here is option B, court may presume its execution. Question number 619. Period of 30 years under section 90 of the Evidence Act is to be reckoned from the date on which the document is relied upon, the date on which the document is filed in the court, the date on which the document is tendered in evidence when its genuineness becomes a subject of proof, all of the above. Here correct answer is option C, that is the date on which the document is tendered in evidence when its genuineness becomes a subject of proof. Question number 620. Execution of a document may be presumed if the document is to be old. Correct answer is option C, that is 30 years. Question number 621. Section 90 of the Indian Evidence Act applies to testamentary documents, non-testamentary documents, testamentary, non-testamentary documents, none of the above. Correct answer here is option C, that is testamentary and non-testamentary documents. Question number 622. A document said to be in the handwriting of A, that document is produced from proper custody. If the document is purporting or proved to be 30, 15, 20 years, 12 years old, court may presume that is in A's handwriting. Here correct answer is option A, 30. Question number 623. 30-year-old document is produced from a proper custody. Here court may presume its execution. Question number 624. The presumption under section 90 of the Evidence Act can be drawn in respect of original documents only, certified copies only, uncertified copies only, all of the above. Correct answer here is option A, that is original documents only. Question number 625. In case where a document proved to be 30 years old is produced from proper custody, which of the following presumptions will the court make? Option A, the court makes irrebuttable presumption that the contents of the documents is true. The court shall presume that the person who had custody of the document is the executor of the document. The court may presume that the signature and the handwriting is the signature and the handwriting of the person to be and was duly executed and attested. The court shall not make any presumption as to its validity or its execution. Here correct answer is option C. The court may presume that the signature and handwriting is the signature and handwriting of the person to be and was duly executed and attested. Option C is the correct answer. Question number 626. Due execution of a document more than 30 years old coming from proper custody is a rebuttable presumption of law, presumption of fact, irrebuttable presumption of none of the above. Correct answer here is option B, that is presumption of fact. Question number 627. How many years old electronic record will be deemed to be proved if it is proved from any custody which the court in particular case considers proper? Correct answer here is option A, that is 5 years. Question number 628. When a document purporting to be a power of attorney duly authenticated as required by law is produced, here correct answer is option C. The court shall presume its execution and authentication. Question number 629. Under Indian Evidence Act 1872, reports published in the newspaper are no evidence at all. Here option D is the right answer. Question number 630. Which of the following is the best evidence? Documentary evidence, direct evidence, hearsay evidence, circumstantial evidence. Correct answer here is option B, that is direct evidence. Question number 631. Electronic record presented for inspection of the court under Indian Evidence Act 1872 is a documentary evidence. Question number 632. Match list first and list second. List 1. Presumption as to books, maps and charts. Correct answer here is section 87 of the Indian Evidence Act. Presumption as to power of attorney. Correct match here is section 85 of the Evidence Act. Presumption as to telephonic messages. Correct answer here is section 88 of the Evidence Act. And presumption as to plans made by the authority of government. Correct match is section 83 of the Evidence Act. Question number 633. Presumption as to gazettes in electronic form. Here correct answer is section 81A of Indian Evidence Act. Presumption as to maps or plans made by authority of government. Correct match here is section 83 of the Indian Evidence Act. Presumption as to genuineness of certified copies. Correct match here is section 79. And presumption as to documents produced as record of evidence. Here correct match is section 80 of Indian Evidence Act. By going through these options, correct match here will be option A. Question number 634. Which of the following is not correctly matched? Presumption as to contents, presumption as to documents of 30 years old, section 90 of Indian Evidence Act is a correct match. Burden of proving that person alive who has not been heard for 7 years, section 108 of Indian Evidence Act is also correct. Dumb witness, section 119 of Indian Evidence is correct. Presumption as to dowry death, section 113A is not correct. Here incorrect is option D. Question number 635. Written document must be proved by writing only. This maxim has been incorporated under which of the following sections of the Indian Evidence Act? Correct answer here is option B, that is section 91. Question number 636. Section 91 of the Evidence Act applies to only to the transactions which under the law must be in writing, only to the transactions which are reduced in writing, both A and B, none of the above. Here correct answer is option C, that is both A and B. Question number 637. Best evidence rule is exclusively associated the rule laid down in. Correct answer is option D, that is section 91 of the Evidence Act. Question number 638. Bar of exclusion of oral evidence by documentary evidence under section 91 and 92 of the Indian Evidence Act 1872 applies. When fact to be proved would invalidate the document. When fact to be proved shows in what manner the language of the document was related to existing facts. When fact to be proved relates to want or failure of consideration. When the fact to be proved relates to terms of contract reduced in form of document. Here correct answer is option D. Question number 639. Which of the following sections are based on the principle of superiority of documentary evidence to oral evidence? Correct answer is option D, that is section 91 and 92. Question number 640. Which of the following observations is correct? Section 91 and 92 of the Indian Evidence Act may not be abrogated by special law. Section 91 does not apply. Section 92 also does not apply. The law of estoppel does not override section 91 to 94 of the Indian Evidence Act. Section 91 and 92 apply even if there is no completed and binding contract. Here in this question it has been asked which of the following observation is correct. Observation B is correct. Where section 91 does not apply, section 92 also does not apply. Option B is the right answer. Question number 641. Section 91 of the Evidence Act prohibits admission of oral evidence to prove the contents of a document where writing is a fact and issue. Option B here is the right answer. Question number 642. Where a bill of exchange is drawn in a set of 5, how many of them need to be proved? Correct answer here is option C, that is 1. Question number 643. Assertion A gives B a receipt for money paid by B. Oral evidence is offered for the payment. The evidence is admissible. Reason: the receipt is not a contract or grant in respect of which the oral evidence is barred. Here option A is the correct answer, that is both A and R true and R is the correct explanation of A. Question number 644. A gives B receipt of money paid by B. Oral evidence is offered to prove the statement. The evidence is admissible. The evidence is not admissible. Section 90 of the Indian Evidence Act deals with this aspect. None of the above. Correct answer here is option A. The evidence is admissible. Question number 645. Point out the incorrect statement. If a contract is contained in several letters, all the letters in which it is contained must be proved. If a contract is contained in a bill of exchange, the bill of exchange must be proved. If a bill of exchange is drawn in a set of 3, one only need to be proved. Option D. If A gives B a receipt for money paid by B, oral evidence is offered of the payment. The evidence is not admissible. Here incorrect statement which has been asked is D. Therefore D will be the correct answer. Other statements are correct. Question number 646. A agrees in writing to sell a horse to B for rupees 1000 or rupees 1500 to show which price was to be given under Indian Evidence Act. Evidence can be given, evidence cannot be given. Evidence can be given by the court's permission, can be proved as secondary evidence. Correct answer here is option B, that is evidence cannot be given. Question number 647. Section 92 of the Evidence Act is applicable to disputes between the parties to the instruments only, two strangers where the document is in question, the party to the instrument and stranger, all of the above. Here correct answer is option A. Section 92 of the Evidence Act is applicable to the disputes between the parties to the instrument only. Question number 648. Section 92 of the Evidence Act applies to bilateral documents, unilateral documents, both A and B, either A or B. Correct answer here is option A, that is bilateral documents. Question number 649. Oral evidence of fact invalidating the document is admissible under. Correct answer here is option A, proviso 1 to section 92 of the Evidence Act. Question number 650. Any fact may be proved which would invalidate any document or which would entitle any person to any decree or order relating to thereto, such as fraud, intimidation or illegality, want of due execution or want of capacity in a contracting party, want or failure of consideration or mistake of fact or law, all of the above. Here correct answer is option D, that is all of the above.